Swayam Prabha. Digital India. Educated India.
Hello everyone, I am Dr. Kavita Solanki, Professor of Law at Guru Gobind Singh Indraprastha University, Delhi, Dwarka. So today we will talk about Labour and Industrial Laws 1, into which this is the first lecture. Here we would be talking about labour law reforms. When we talk about the labour law reforms, labour law is a continuous process and has been carried out through the amendment of the labour laws over time. Labour laws in India fall under the concurrent list of the Constitution of India and therefore are governed by the numerous central and state legislations on plethora of topics. From where these labour law reforms came? Because in India, labour law is very complex and it falls into the concurrent list having 40 central legislations and 100 state legislations. They are very old, not up to date. It had been realized by the first National Law Commission was set up in 1966 headed by Justice Gajendra Gadkar, and it was in 1999 by the Atal Bihari Vajpayee government. They set up the second National Labour Law Commission headed by Shri Ravindra Verma. Both the commissions, they proposed to have the 4 or 5 labour codes for the better implementation of labour law instead of having so many labour legislations, and proposed to include unorganized sector into the ambit of labour law protection. Accordingly, out of 44 central labour laws, 29 has been amalgamated into 4 labour codes and notified. 12 laws has been repealed. 29 because we had the total 44, and out of 44, 29 has been amalgamated into 4 codes. So 29 is this side plus 12 laws has been repealed. It means we are having the 41 here, and total we had the 44. And these 3 remaining labour legislations, that is labour laws, exemption from furnishing returns and maintaining register by certain Establishments Act 1988 is awaiting for the repeal. Child and Adolescent Labour Prohibition and Regulation Act 1986 and Bonded Labour System Abolition Act 1976 would remain on standing on that is a basis. They are also on a same footing. The name, so because as proposed by Justice Gajendra Gadkar and Shri Verma, so these labour laws, they have been amalgamated, they have been codified, they have been subsumed into the 4 codes and which are incorporated into the given list. So first is when we talk about, that is category 1 is where we have amalgamated the 4 labour legislation, that is a Code on Wages 2019. When we are talking about Code on Wages 2019, it subsumed 4 labour laws. These are Payment of Wages Act 1936, Minimum Wages Act 1948, Equal Remuneration Act 1976, Payment of Bonus Act 1965. Second category is that is, it talks about, because these laws, these 3 laws has been subsumed into this code, and the name of this code is Industrial Relations Code 2020, into which these legislations has been amalgamated. Number 1 is Industrial Employment Standing Order Act 1946, Industrial Dispute Act 1947, Trade Union Act 1926. And the third category is, that is Occupational Safety, Health and Working Conditions Code 2020, into which we have amalgamated so many labour legislations, say Factories Act 1948, Mines Act 1951, Dock Workers Safety, Health and Welfare Act 1986, the Building and the Other Workers Regulation of Employment and Condition of Service Act 1996, the Plantation Labour Act 1951, the Contract Labour Regulation and Abolition Act 1970, the Interstate Migrant Worker Regulation of Employment and Condition of Service Act 1979, the Working Journalist and Other Newspaper Employees Condition of Service and Miscellaneous Provisions Act 1955, the Working Journalist Fixation of Rates of Wages Act 1958, the Motor Transport Workers Act 1961, Sales Promotion Employees Condition of Service Act 1976, the BD and the Cigar Workers Condition of Employment Act 1966, the Sign Workers and the Cinema Theatre Workers Act 1981. Here we have amalgamated 13 legislation into this code. And the fourth category is, it is on a social security basis. So, they are subsumed into the Code on Social Security 2020, into which we have amalgamated these 9 legislations. These are, number 1 is the Employees Provident Fund and Miscellaneous Provisions, Employees State Insurance Act 1948, Maternity Benefit Act 1961, the Building and the Other Construction Workers Cess Act 1972, the Payment of Gratuity Act 1972, Employees Exchange Compulsory Notification of Vacancies Act 1959, the Sign Workers Welfare Fund Act 1981, the Unorganized Workers Social Security Act 2008, Employees Compensation Act 1923. So, we have basically amalgamated all these things, because how we have categorized the criteria is some on the basis of the social security, some on the basis of the occupational safety, health and the working conditions, and some on the basis of the employer and the employee relationship, and some are on the basis of where we are talking about the wages. So, this is the category, and it has been proposed by the commissions, both the commission, that we are not having any labor legislations that is for the unorganized sector, because when we talk about NSSO, it has been surveyed. When we are talking about the NSSO, it has been, that is a report has been given by that is in 2010. We are having so many labor legislation, but only we are covering, that is 8% of it. We are not having anything for the 92% of the labor class, which is 92%. So, it had been proposed to have the reforms into the labor law, and we would be talking about the reasons behind it, because it is not easy. When we talk about at the world level, we are having the voluminous of the labor laws, but when we are talking about the implementation part, we are having the great difficulty for the implementation of the labor laws, in spite of having so many voluminous legislation for the labors. So, this is a much needed reforms, and the reasons for this, number 1 is multiplicity of the labor laws and the need for a fewer labor legislations, if not a single labor code, because already we have discussed that there are 36 legislation at the central level and more than 150 legislations at the state level to deal with the labor, because the labor is, that is, it comes under the concurrent list which has been provided by the constitution. So, where the state government thinks so, they need a labor law, they can frame the labor law for that respective state, and the central government, they can frame it at this central level. So, we are having the too much labor laws, and there are the most voluminous into the world. More laws means less implementation if the inspection and the enforcement machinery is limited, because we hadn't this much of the enforcement machinery for the application of the labor law. And the first National Labour Commission on Labour Enforcement Machinery Association favored a single labor code and even prepared a draft of it. The first Labour Commission, they proposed the single, they were very fed up, like having so many labor laws, but no proper implementation. They proposed to have the one labor code. And the second National Labour Commission on Labour, they grouped the entire labor law into the 4 or the 5 categories. And the second reason for having the labor law reform is multiple definitions of the same or the similar terms to be eliminated, because into the labor law we are having the so many definitions and we are not having the uniformity into the definition. This is a big problem. Say for example, when we talk about Industrial Dispute Act 1947, it defines the workman, right? Factory Act it defines the again Factory Act 1948, they are also defining the Factory Act. Employee State Insurance Act, they defines employees in a different way. It creates a confusion, and in order to bring the uniformity, the term worker should be uniformly adopted and defined as suggested by the second National Labour Law Commission in all the labour legislations. So, through the course now, the government has implemented the similar definition throughout the 4 codes. So, there would be easy implementation and easy understanding with these concepts. Next is, say sometime the expression is appropriate government again has been differently defined in various labour legislations. In order to reduce the conflict and bring uniformity, there should be a single definition. The 2010 amendment into the Industrial Dispute Act 1947 has however provided the guideline for this, and so, and when we are talking about, so that is a problem with the appropriate government. And if you are talking about the term that is of wages, wages again has been defined differently under the Minimum Wages Act. The different definition has been given by the Payment of Wages Act 1936, Payment of Gratuity Act 1972, they have defined the differently. And if we are talking about the wages which has been given under the Industrial Dispute Act, they have defined it differently. So, now if we are talking about the definition of the wages under the code, because I told you the definition would be uniform in throughout the 4 codes. So, now under the code on wages, 2019 has defined the wages. The similar definition has been used into the all the 3 respective codes. So, definition is wages means and this is very important definition, and definition is given, that is wages means all remuneration whether by way of salaries or the allowances or otherwise, if the terms of the employment were fulfilled, be payable to a person employed in respect of his employment. And wages means only the 3 components has been taken into the consideration, that is it includes basic wages, dearness allowances and retaining allowances, because basic wages is that is very at the when we join any of the establishments, that is initially we fix the wages. Dearness allowances is that is of course it has been revised and it has been proposed even into the code is it would be revised twice in a year, like in April and in October it has to be revised. And when we are talking about the dearness allowance, if we talk about the intention behind the dearness allowance was to give the just to minimize the cost of living index, because sometimes it is not possible to take care of because of the increasing cost of living index. If we are having the good DA, we can minimize that is that is the we can minimize this this cost. And after that, that has been proposed that that is when we talk about the social security, it has been proposed by into the earlier time, that is it has been proposed up to the 90% the DA has to be given, up to the 95%, but of course this is not possible here in India due to the most populous country into the world. So, and the third is the retaining allowance. So, this is the new thing has been added, and after that now we are removing the confusion, that is the components which won't be covered under the definition of the wages are, that is bonus is not the part of the wages, PF provident fund, that is not the part of the wages now, conveyance allowances again that is not the part of wages, house rent allowance is not part of wage, overtime allowance it is not a part of wage, any kind of the commission or gratuity, retrenchment compensation, we are having these different heads, but they are not the part of the wages. So, now we would be having the uniform definition of the wages throughout the 4 codes. And I told you that there is a problem into the vague definition or multiple definitions. So, again one of the definitions is very important, that is when we are talking about the scope of the industry under the Industrial Dispute Act 1947 and establishments under the Industrial Employment Standing Order, Despite the judicial interpretation, it is still unsettled and needs to be simplified, because this is a story before passing of the code. When we are talking about the definition of the industry, first definition that is given in your Industrial Dispute Act 1947, and here in section 2J the definition of the industry is defined, that is, industry means any business or trade, undertaking, manufacture or calling of employers, and includes any calling, service, employment, handicraft or industrial occupation or avocation of workmen. And it includes into this, that is, they are talking about the definition of the industry, and here into the 2J of the Industrial Dispute Act we had so many exceptions, 10 exceptions has been given. Those will not be considered to be the into the definition of the industry. Say for example, when we talk about the hospitals, when we are talking about any of the research institutes, when we are talking about the educational institutes, when we are talking about the universities and many more, they have been excluded from the definition of the industry. In fact, in 1978, this is a very leading case. Just to avoid all this confusion, Supreme Court with a large bench, they came up with the principle, that is the definition of the industry, and they devised a formula, that is a triple test, in Bangalore water supply case versus A. Rajappa in 1978. And after that, again in the year 1982, Industrial Dispute Amendment Act came, and they gave the definition of the industry. That is, they have given the definition of the industry means any systematic activity carried on by the cooperation between the employer and his workmen, whether such workmen are employed by the employer directly by or through any agency, including a contractor, for the production, supply or distribution of goods or the services with a view to satisfy human wants or wishes, that is, not being wants or the wishes which are merely spiritual or the religious in nature. So, whether or not any capital has been invested for the purpose of carrying on such activity, or such activity is carried on with a motive to make any gain or the profit, that is not bothered whether what kind of intention they had, whether they had the intention to make a profit or to gain something. So, like if they are carrying such a kind of the activity with the cooperation of the employer and the workmen. So, that was the definition of the industry, and they included any activity of the Dock Labour Board's establishment under section 5A of the Dock Workers Act, any activity relating to the promotion of sale business or both carried on by any of the establishment, but does not include any agriculture operation. They excluded these things, any agriculture operation, except by where such operation is carried on in any integrated manner with any other activity, and such activity is a predominant one. So, when we are going for the explanation of this act is, but does not include any activity into this thing. So, they were not including these things into the definition of the industry. Hospital or the dispensaries or educational, scientific, research or the training institutions owned and managed by the organization wholly or substantially engaged in any charitable, social or the philanthropic services, or khadi or village industries, or any activity of the government relatable to the sovereign functions of the government, including all the activities carried on by the department of the central government dealing with the defense, atomic energy and space, any domestic services, or any activity being a profession practiced by the individual or body of the individuals, if a number of the persons employed by the individual or body of the individual in relation to such a profession is less than 10. Say sometimes a case of the professionals, advocates, doctors. So, we have excluded all this, and any activity being an activity carried on by the cooperative society or a club or any other like body of the individuals, if the number of the persons employed by the cooperative society, club or other like body of the individual in relation to such a activity is less than 10. So, now when we are talking about these things, there was a great confusion which definition will come into the operation, whether the definition which has been defined in section 2J is that is relevant in 1982, or the definition which has been given in your that is in Industrial Dispute Act 1947 would be applicable. So, just to overcome this difficulty, the code came up with the definition of the industry. Now, the next problem was that is a salary limit. Again, this was a big problem because the salary limit provided under the various labor legislations has become obsolete, and there is a wage limit under the Payment of Wages Act 1936 is that is 2000 per month. This is after the amendment, that is in 2016 or 17. So, that has been wage limit has been increased, and likewise in 2010 amendment into the Industrial Dispute Act, they fixed the wage limit for the workers doing the supervisory work at the 10,000 per month. On the contrary, there is no wage limit for the persons doing the technical skilled work. It requires a serious attention because they must have to address this problem as well. Now, that again problem was the number of persons, because in any of the, either we are talking about Industrial Dispute Act, Factory Act, or any other establishments, because the threshold was not uniform. I mean, how many persons has to be employed into the different different act, a different number has been given. So, I mean, again it creates a great confusion. So, minimum number of the persons prescribed under the various labor legislations, including the social security and the minimum standard legislations, need to be reviewed. Now, this thing has been revised under the code. Again, the problem was simplifying and rationalize laws. The substantive law and the procedures prescribed under the various labor legislations had to be simplified and it had to be rationalized. For this purpose, only the code has been drafted to make the more things simplified. So, when we are having the great expectations from the code. So, with this intention, this the code has been simplified and has been rationalized. So, maximum benefit can be given to the needy. Laws regulating these strikes and the lockouts, because again few things had to be taken into the consideration, and that is why they had been reviewed. And because when we talk about minimum period of the notice must be prescribed for the strike and the lockout in non-public utility services, because when we talk about under the Industrial Dispute Act 1947, into which the first schedule of the 1947 Act is, it talks about that is the public utility services, because into which that is a list has been given. Say for example, banking services, hospital, already everything has been given into the schedule. So, if these workers they are going for the strike, this is a mandate, they had to give the notice in advance to the government. But what about the non-public services? What about the non-public utility services? That is why it had been, that has been recommended that the minimum period of notice must be prescribed if there is someone is going on for a strike, or if the employer they are thinking for the lockout. And secret ballot method for restoring this to strike may be considered, because more confidentiality can be maintained through it. Penalties prescribed for the illegal strike and the lockout should be deterrent in nature, because if we are talking about if the person is not deterring, they are doing the offence again, there is no sense. So, that is why it has been proposed that the penalty has to be to that extent the person will dare to do that kind of this act. Just go slow, stay in strike should be treated to be the serious misconduct, because when we used to talk about the go slow strike, it was not considered to be, I mean it was not considered illegal strike earlier. When we talk about the strike under the Industrial Dispute Act, stay in strike, so they are, of course, they are considered to be misconduct. So, and all these the proposed things, they have been considered now under the code, and that is why these things they have been listed into the one more schedule of the Industrial Dispute Act 1947 into the category of the unfair means on the part of the employee. The next problem is regarding the notice of change under section 9A of the Industrial Dispute Act 1947. This needs to be reviewed, particularly where the employees expand the business or increase the strength of the labor. Mere display of notice is not sufficient. If the employer is, they are putting the notice, that is not adequate, because like if we are talking about in one of the case in management of Salem District Cooperative Milk Producer Union Limited versus Industrial Tribunal, the Madras High Court has held that mere display of the notice on a notice board will not be sufficient. The notice must be in terms of the provisions of the Industrial Dispute Act, and so the Tamil Nadu Industrial Dispute Rules, which inter alia stipulates that it must be exhibited into the Tamil, and recovery of the payments towards the inadmissible allowances and incentives. So, in one more case, in Joshi versus Flag Officers Commanding in Chief, the Kerala High Court had held that recovery of the payment made towards the inadmissible allowances made by mistake is not violation of section 9 of the Industrial Dispute Act 1947. Either someone by chance, mistakenly, they have given for this kind of the allowances, they can take the money back. Transfer of the employees in Associated Cement Company Limited versus Cement Staff Union, the Bombay High Court has held that transfer of an employee being an incident of service, and there is no question of the order of the transfer not being violation of section 9 of the Industrial Dispute Act. So, they can go for the transfer. So, we had these kind of the issues into the legislations. Government permission for the retrenchment, layoff and the closure of the enterprises. So, again, a drastic change has been made here, because earlier the issue was whether the management employ 100 workers or more should seek the prior permission, prior approval of the appropriate government before the layoff or the retrenchment or close down. So, when we are talking about so many Maruti case and the other cases, because do they require the permission from the government if they want to go for this kind of the process, either the layoff or the retrenchment, or they want to close down the industry. So, and whether the existing limit of 100 should be raised to 300, because it is very easy to remove the 100 workers. So, do they need the government permission for this thing? It is now taken into the code on the industrial relations, which has been proposed. So, now the threshold has been increased from 300 to that has been increased from 100 to 300 workers. Now, the next problem is, because these are the issues we are talking about, where we can say that much needed for the labor law reforms. The problem for enforcement and the compliance of the labor laws, the existing labor legislations does not fully address the problem of the enforcement. This is lack of enforcement, and this is more evident in case of the unorganized sector. And when we are talking about, and this thing has not been, because when we see unorganized sector, already we have seen at the time of the COVID, because majority of the persons, they were the migrant workers or the unorganized sectors, because already we were the witness of it. We have seen the that is a problem or of the unorganized sector at that moment. The panel provisions, particularly in case of the illegal strike, lockout, has remained on a paper, because either someone is going for the lockout or on a illegal strike, I mean, no one take it very seriously. No one is, and it is felt that it is better not to have a law which is respected more in a breach than it is in observance. It is further felt that so long as the cost of violation is less or negligible than the cost of a compliance, provision of the labor law would remain on paper, because already we have seen that, because so many, already we have seen that, like if the someone is not making the compliance, of the labor law, already we have observed a very less fine or the penalty has been proposed. So, this is like, it will not give any deterrent effect to it. That is why it creates a more problem. And when we are talking about labor law reforms, is That is, it is much needed, because this is a time, because India is, everyone is looking at the India with a very respect, So, but when we see the condition, and this is everyone noticed that India is very famous for the cheap labor, no compliance, and these kind of things. So, this thing has been noticed, and the government is working on it, because if we are talking about ease on doing business, this is very, very important, and ease on doing business is a basic necessity, and for the smooth functioning of the growth of the economy in general, with the policy focus on the rationalization, simplification and digitalization of the regulatory compliances, India has remained firm on the path of ease on doing business. So, with the plethora of labor reforms, with the plethora of labor law, since independence, which was supposed to be simplified for the ease of doing business through 4 codes. To start any business needs, because if we are talking about ease on doing business, it means how much the person is easy, and within a speedy, the clearance of the licenses, whether the person is able to start the businesses on time. So, to start any business needs so many licenses, and because when we talk about ease on doing business, this is very, very important, and for this, if we are talking about the ease on doing business, normally what happened, 10 parameters has been decided, and this is the normally the World Bank conduct this, this kind of the thing, and if you are talking about the World Bank report, India had been placed on, now India has been placed on 63rd rank out of 190 nations in ease on doing business in 2020. The Indian government began a comprehensive program of regulatory reforms in 2014, and with the goal of facilitating business operations. So, they can attract the FDI into this thing, into India, and so World Bank found that is India is improving, and when we talk about ease on doing business, that is the 10 parameters had been taken into the consideration by the World Bank. These criteria are number 1, how much easy to starting of the business, how much easy it is starting of business, to take the construction permits, getting electricity, registering property, getting credit from the banks, protecting minority interest, paying taxes, trade, enforcing contracts, and resolving insolvency. So, resolving insolvency and the bankruptcy code, which had been passed in 2016, it has played a very good role into that. So, this is one of the component by which we could improve our ranking, and when the World Bank, they are doing this kind of the research, but this is a good thing. We, of course, India is improving, we are holding a good rank out of the 190 nations, but one of the limitation is there, that is World Bank take into the consideration 2 metro cities in India only, that is Delhi and the Mumbai, for ranking ease on doing business, because we are having Bangalore and many more cities, those are the metropolitan cities, but only the World Bank take the India and the Mumbai into the consideration, that is for the ease on doing business. And so, after that, why we need a labor reform is they are much needed, because if we are having the good, in terms of the ease on doing business, the other country, the foreign direct investments would be, we can attract the FDIs into the country, and so they would be, they will love to come, and because if the compliance would be easy, there won't be any problem, then every would be, because the India is a very good and the great destination for this purpose, and so in the initiative significantly contributes to the attempt to improve the business climate. India is now one of the most alluring location for the investment and conducting the business. India moves up to 79 spots in the world rank 2020 ease of doing business ranking from 142 in 2014 to 63rd in 2019. It means to start business is easy and timely clearance to start any business in India. So, and when we are talking about ease on doing business, New Zealand is a country, which stands on the first rank in terms of the ease on doing business as per the World Bank report. And so, because we had these issues, because when we were talking about much needed for the labor reforms, and we can say that now what is the outcome from the labor law reforms? In fact, we are ready with the codes, but some says we are ready with the codes, but why they have not been implemented? Because the reason is labor law is I told you earlier, that is it comes under the concurrent list. Once the state government they would be ready with the rules, then the compliance can be made. So that's why earlier the date has been, it was a plan to pass the labor law in July, but a few states they are not ready with their rules. That's why it could not be implemented fully. So out of these reforms, what are the outcome from the labor law reforms? Does it simplify the labor law, or does it more complicated the labor law? Now this is the problem, because why we are using the word is complicated, because now we are having the so many sections. Already we have realized that in so many codes, into code on industrial relations we had the 3 codes. We were talking about the code on wages, the 4 legislations has been amalgamated. When we are talking about the code on occupational health and the safety, the 13 legislations already there. When we were talking about the code on social security, 9 legislations they had been simplified and amalgamated into it. That's why the question here is like whether we are going to make the labor law more simplified or whether we are going to make it more complicated. So with this we can say that no very good changes has been made. Say if we are talking about the code on the industrial relations, earlier we had so many authorities. If we are talking about the into the Industrial Dispute Act 1947, we had the system of the adjudication, non-adjudicating authorities, we had the adjudicating authorities. When we talk about non-adjudicating authorities, we had the work committee, we had the conciliation officer, we had the board of inquiry, we had the court of inquiry, we had section 3, 4, 5, 6 of the Industrial Dispute Act, we had the board of conciliation we had. So too much authorities had been given, and if we were talking about that is for the adjudication, we had the labor court, we had the tribunals, we had the national tribunals, but and later on it had been amended and arbitration had been included to resolve the disputes, just to avoid the pendency of the cases into the court. So if we are talking about under the code is, now we are not having too much authorities, because the timely speedy disposal of the cases is the main target. That's why the 2 authorities under the code has been included. The conciliation officer is there and tribunal is there. Now we won't be having the other authority, that is non-adjudicating and the adjudicating authority, and we are having the voluntary arbitration. Both the party they are okay with that. If they are agree, so voluntarily they can go for the arbitration. So we are expecting the speedy disposal of the cases now. And next is outcome of the this code is recognition of the trade union, because otherwise we had the Trade Union Act 1926. See, we are dealing with all these issues regarding the that is how the trade union can be registered, who can form the trade union, grounds for the cancellation, how the immunity can be given, like that is the criminal immunity and the civil immunity and the other things. But as far as, because we are talking about the collective bargaining, right? So, but this is these trade union, they were not recognized till date. So that it was a very crucial issue into the labor law, which relates to the recognition of the trade union, and that is because there is no provision in any central labor legislation for the recognition of the trade union by the employees. The basic issue is about the mode of determining the bargaining agent, and the federation of the trade union is divided over the issue, or whether the verification of the secret ballot method should be adopted. No doubt several legislative attempts has been made, but till date, except in few states, there is no central legislation to deal with the recognition of the trade union. But when we are talking about under the code is, because now if any of the trade union is into in any of the industry, if they are having any of the trade union, it has to be recognized. Second is, the condition is we are having the negotiating council. Now under the code is it has been given that negotiating council, if any of the trade union is having 50%, or if they are having the more than, if the single trade union is there, has to be recognized. If we are having the federation of the unions and they are having the majority is up to the 51%, then it has to be recognized. So this is a good thing has been done. After that, Code on Social Security, that is 2020, because labor laws are having more extended to include the casual workers now, and migrant workers, contract workers, and it includes the gig workers and the platform workers. Because earlier when we talk about the casual workers, we hadn't any protection for the casual workers. When we are talking about the migrant workers, we are having the legislation for the migrant workers, but we have seen the condition at the time of the COVID, and contract workers, and it includes gig workers and the platform workers. When we are talking about gig workers, all the time we are using the Ola, Uber and everything, So now the more protection would be given into the gig workers, and platform workers has been included, because all the time nowadays the time has been changed, and if we are having if something can be done on a digital platform, normally we see this stand in metropolitan cities, and normally we are using the Swiggy, Zomato and everything, for the food delivery and for the grocery and for the other kind of the items. So the protection has to be given into these workers, So under this code, it has been, that is the more protection, more coverage has been given. So for the first time, we are including the gig workers or the platform workers under the code. More protection has been given to the unorganized sector through the labor code, because the reason is we hadn't any labor legislation which were talking about the protection of the unorganized sector. Only in 2008, that is Social Security Act 2008 has been passed, but that was a toothless legislation, because at the time it had to be applicable upon the below poverty line, and for the better implementation, because this could not be implemented well due to the lack of the data of the workers. So now it had been realized, because 92% of the population, those who are doing into the work, that is a labor workforce participation, I would say, that is comes under the unorganized sector, 92%. So now it had more coverage has been given to this sector through the codes. Gig workers had been protected, already discussed. Now the migrant workers definition has been changed, and it includes the direct and through the contractor, because earlier we used to say that is either someone is coming through the contractor would be considered to be the migrant worker, but now we are either someone is coming directly, so would be coming under the definition of the migrant workers, and the protection would be given either the migrant worker himself directly coming or coming with the contractor. So the protection would be given to them. Now this code gives more power to the employer to hire and fire. You have to decide, because the more protest has been made by for this reason is by the Bharatiya Mazdoor Sangh. They were protesting it, because into this code, if the employer wanted to shut down any industry, had to take the permission from the government if they were having the 100 workers, because earlier it was applicable upon the 100 workers. If any of the employer they wanted to shut down the industry, they had to take the prior permission, but the threshold was the 100. But now the threshold has been increased from 100 to 300. It means either someone wants to shut down the industry, want to close down the industry, the employer, they do not have to take the permission from the government. So, now the code says standing order necessary only for the industry with more than 300 employees. If the employer is having less than 300 employees, it will reasonably free system of the hire and the fire. The second problem is regarding the this thing is that is for the standing order. When we used to talk about applicability of the standing order, Industrial Employment Standing Order Act 1946, it had been made that was the provision that would be applicable upon the establishment where the numbers of the workers are 100 or less, but now this threshold has been increased, that is from 100 to 300 threshold has been increased. That is why it has been opposed by the Bharatiya Mazdoor Sangh. Now, the next is again outcome of this code, Occupation Safety, Health and the Working Conditions Code 2020. Earlier into the Factory Act 1948, the threshold for the manual work was 20 and with electricity it was the 10. Now, this threshold has been doubled because it is considered no work is without the electricity, because when we used to otherwise when we talk about definition of the industry. So, already under the Factory Act it has been mentioned that in case of the manual work, if they are having the 20 persons, and in case of that is a work with power with electricity, if the number is 20, it used to be coming under the definition of the industry. That was one of the component of the factory. But now this threshold has been doubled. It means those who are doing the manual work has to be 40, and in case of those who are doing the work with electricity or with power, the number is 20. So, almost it has been doubled now. And into the factory, special provisions has been created for the protection of the women workers, because this was the set provision under the Factory Act. In fact, the protection has been given under the Factory Act that no female would be coming, no employer can call any of the female into the factory before the sunset or after the sunrise. So, because it was expected the female would be more secure at their homes. So, that is why they were not taking the female into the factory for this time after the sunset or before the sunrise. But now this thing has been removed, and we used to say that like where the cotton work is going on into the factory, because the females they were not the part of it, or otherwise they could not set up into, they could not stand into the rear this thing, so like they would be given the protection under that. And earlier the females were debarred from the doing the work, hazardous work, but now no job is considered hazardous for the women, and now the women are considered to be fit for every kind of the job. Like when we talk about the fighter pilot or the other kind of the work, if we try to recall Republic Day, so we were the witness of it, how the female they were participating at that time. So, that is why they are saying if the female they are doing the work into the factory, they want to engage themselves, they want to earn more and more. So, equally they should be treated, there should not be any discrimination on the basis of this sex. After that, if we are talking about coverage, license and the registration, now under this code more coverage has been given, and licenses, because already we have discussed the point that is on doing business. So, now things are easy, and the registration. So, now we are having the more coverage, easy licenses, and the registration, online registration can be done, and the code is aid in speedy disposal of the disputes related to the labor. So, that is why this is the basic idea, not to go for the pendency of the dispute. So, speedy disposal of the dispute is one of the agenda of this code. And for this under the code a very good provision has been added, that is a reskilling fund has been created for this purpose, because they would be either someone is doing kind of any kind of the PT offensive, for example, then if the fine has been imposed, this fine can be collected into this fund. So, the reskilling fund has been created under the code nowadays. And when we are talking about the one more code is code on wages 2019. So, again the better coverage has been given, because earlier when we because under the code on wages 4 legislation has been amalgamated, and minimum wages is one of that legislation. So, when we are talking about applicability of the minimum wages, that would be applicable upon the employment which has been given into the schedule. So, it would be applicable upon the schedule employment which has been given into the minimum wages act. But now under the code more coverage has been given. So, that is now they are irrespective of the limited coverage schedule employments, it would be universally, it would be applicable upon the all employments. And when we are talking about again a very good point has been very good thing has been done under the code is concept of national minimum wage, because under the minimum wage act we used to talk about minimum wage and the other kind of the wages. So, whatever we hadn't any uniform definition of the minimum wage, but only with the help of the judiciary good kind of the criteria has been decided when we are talking about either the contribution of the Labour Law Commission, Royal Commission, they have given their recommendations how to decide the minimum wages is, and they had been taken into so many cases like Kamini Metals case, because into which we were talking about the 5 norms which has been taken into the consideration for the fixing of the minimum wage of the workers. So, not only to maintain the efficacy or the efficiency of the workers, or just to give the better food quality and the other things. So, we are having the 5 norms principle for this. But in spite of it, because your minimum wages were not universally applicable into all the states and into the all establishments. So, here the this thing has been proposed, national minimum wage has been developed. So, more protection has to be given to the organized and the unorganized sector, because it has been proposed by the first Labour Law Commission on Labour, and they recommended, they said national wage is not easy. That is because we are having the diversity, we are not having the uniform regions. So, it has been recommended that national wage is not necessary because of the wide variations due to the socio-economic and the demographic conditions, not only in various states, but also at the regional or the district level within a states, we cannot have the uniform rate of the minimum wages. It has been observed by the first National Labour Commission, but there is a need to examine whether there should be a national floor of the wages for all the scheduled employments, because it is the outcome of the code on wages, national minimum wage. It means the central government would be fixing that is a national minimum wage throughout the country. If any of the state they want to, and there is a mandate for all the states, they can give them the wages, but they cannot shrink their wage limits. They can increase the wage limits. For example, if the central government has said minimum wages would be 5,000, so that cannot be shrink, that cannot be reduced by any of the state, and that is a call of the state. Already they were giving the more wages to their workers. It is, they don't have to reduce their wages. Say for example, when we are talking about Kerala state, they are giving the more wages to their workers. So, with the implementation of the national minimum wage, it is not necessary. In fact, they can have the whatever the wages they are giving. If they are giving the more wages than the national floor of the wages, they can continue with that. The basic idea of the national minimum wage was to give them more protection. That is, the wages should not to be shrink beyond it. And now when we are talking about I mean earlier already we have discussed so many overlapping and the other difficulties we had. So this is the basic idea. All these provisions, they were obsolete and they were not covering many workers. With the help of the new code, we can reach to the maximum, so that we can get the better benefit from the provisions. We can cover every type of workers here. So more protection and the easy compliances has been provided through the labor law reforms. So this was from my side, and thank you so much.
I am A.K. Sharma, and I am Professor of Sociology at IIT Kanpur. The question I am going to address is what is urbanization? Urbanization is essentially the process of population concentration, which means that if more people start living in a smaller number of places, or if the distribution of population becomes more unequal, like more people living in places like Bombay, Calcutta, Mexico, then we say that the urbanization is taking place. Essentially, it means increase in percentage of population living in areas or localities which are defined as urban. Urbanization is a new phenomenon, of course, a post-industrial phenomenon. About 200 years ago, hardly 5% population of the world lived in urban areas, and today more than 50% population of the world is living in urban areas or localities which are classified as urban. You will be happy to know that according to 2011 census of India, in our own country for the first time, increase in the urban population has been greater than the increase in the rural population, though India is not so urban as the developed countries, and about 31% population of India only is living in urban areas. We can believe that in 10 years, 20 years, 30 years time, India will also be more urban, at least more urban than what it is. It may not be 80%, but certainly it will be 35% or 40%. Now, how is this urban locality defined? Because this definition of locality as urban or rural is crucial to measure level of urbanization. I will give you definition of our own country. In Indian census, an urban locality is defined in two ways. There are statutory towns and there are census towns. All places with municipality, municipal corporation, cantonment or notified town area committees are called urban. This is statutory definition. According to demographic definition, there are three main criteria. If a locality has more than 5,000 people, or 75% of male labor force is engaged in non-agricultural activities, or the density of population is 400 per square kilometer or 1000 per square mile, then we say that the locality may be classified as urban. There are many other additions to this definition. Now, we have the concept of urban agglomeration and many other things, but essentially this is how urban population is defined in India. And as I said that urbanization is associated with economic development and industrialization, same is the case with India. About 100 years ago in India, only 11% people were living in urban areas. Today 31% are living in urban areas, and this is obviously linked with economic development of the country, growth of per capita income and industrialization. I remember that in one 5-year plan it was mentioned that today this urban population can grow by way of natural increase of births minus deaths in the urban areas itself or through rural to urban migration. Today nearly 60% contribution to growth of urban population is due to rural to urban migration, and this is going to increase. This is essentially what urbanization means. Urbanization means growth of population in localities defined as urban in relation to population of localities defined as rural, and I have given you Indian definition. Thank you very much.